Call the list, please.
Item number 1.
My lord, in this appeal, my lord, I am being led by Mr. Jishnu Shaha, my lord, senior counsel. He was waiting over here for some time. My lord, he is on legs for 15 minutes in some other court. Can I ask for a short passover for 15 minutes, my lord?
Passover, whether it is 15 minutes or 55 minutes, we cannot say.
My lord, passed over, my lord. Much obliged.
Number 2.
Made, please, Your Honor.
Yes.
Lordship, this matter is pending before Supreme Court, Lordship. We have filed an appeal, Lordship.
Same order as 26 to 25. We adjourn this appeal till 12th May.
Of life.
Number 3.
Yes, please.
My lord, in this matter, my lord, the state has to file a report, my lord.
With regard
Last
to
order, my lord.
which of these inspection reports recommends felling of the trees?
Well, we have just received the,
Lordship, kindly, if Lordship, there is a chart, Lordship, we have
Yes.
for the reference. Lordship, can we come to serial number 1?
Yes.
If Lordship, can you see the location of the trees, number of trees requested for filling, reason cited for filling, then reference, Your Lordship, then re-inspection. Can you come to that box at 6, Your Lordship? Number so and so. Then 7, Your Lordship. 1 tree filling is required as the said tree is leaning. Lordship, in that serial number 1, there are two trees, Your Lordship. Only 1 is required to be felled, Your Lordship. The said tree is leaning dangerously towards the neighboring building.
That is item number?
Serial number 1, Your Lordship. We have made a chart, Your Lordship. Serial number 1.
Application of Papri Mishra.
Lordship, yes.
She requested for 2 trees.
2 trees, Your Lordship. She requested for 2 trees, but after re-inspection, only 1 is recommended for felling, Your Lordship.
That is serial number 1.
Lordship, yes. Then, Lordship, can we come to serial number 2? Lordship, the location of the trees is somewhere in Mauyam Lane. Number of trees required is 20.
No, from serial number 1
Lordship.
to serial number 13, second page.
Lordship, yes.
How many trees, according to you, should be felled?
Lordship, it is, Lordship, can we come to that box 7? Box number 7, Your Lordship. Lordship, out of 2, 1 is recommended for filling. For applicant number 1.
And please come to serial number 11.
11, Your Lordship. 7 lang for you. 89. Oh, 11.
89 trees.
89, Your Lordship.
Trees are to be felled.
Lordship, yes.
my lord, may I say,
Lordship,
the last
only-
petition, my lord has directed to annex the photographs of the trees, my lord. That has been done, my lord, which are supposed to be felled, my lord.
Lordship, this is situated in accident-prone area, Your Lordship, somewhere in Mauyang, that national highway going to Kahati, Your Lordship.
Somebody must be appointed over them to legal. This is too much. 8900, 200 trees being felled.
I'm not sure, 11, no? What is that, 11? It's 11.
So we have said if it is imminent, it's likely to imminent danger, you do it. But these are standing for some time.
Lordship, if Lordship can we come to page 73, so for that 89 trees,
Somebody appointed by the chief secretary. Yes.
Lordship, can we come to page 73? What does this mean? NHIDL. Lordship, this is an application from the NHIDCL, Your Lordship. If Lordship kindly come to the second paragraph of that.
Advocate General is also appearing.
Lordship, yes.
I'm also appearing in this matter, my lord. Mr. Basula.
But this report is by, the recommendations are made by junior forest officers.
Your lordship, if your lordship kindly see, this is a national highway development project where the survey has been carried out by the junior forest officer. If your lordship will kindly see page 75, my lord. Page 75.
Lordship, this report is by the divisional forest officer, your Lordship.
Yes.
And
DFO, your Lordship. Lordship, kindly internal page 3, your Lordship, of that chart. The signature, your Lordship. Internal page 3, your Lordship. In the chart, your Lordship.
Of the report.
Lordship, yes. Lordship, that in the chart, your Lordship, internal page 3.
Raining. Raining. Mr. Advocate General, you please,
yes, your lordship.
you please form a committee of at least 3 senior officers
Yes, my lord.
to review this and to make a
Yes, my
recommendation to us. And also, my lord wants
Yes, my lord.
extension of the operation of this order to other districts also.
Yes, my lord. One submission, my lord. Because the lordship has passed the order. If your lordship kindly see your lordship's order of 7th February 2025. My lord. And your lordship has noted in writ petitioner relied upon in page 2, my lord, first paragraph. In the writ petitioner relies upon Meghalaya Tree Preservation Act 1976 and Meghalaya Tree Preservation Rules 1976, which inter alia provide that before according permission to fell a tree in state, an application has to be made by the divisional forest officer in form 1 of the said rules, followed by inquiry. This is your lordship has taken note of that. Your lordship, it was inadvertently not pointed out, my lord, that Meghalaya Tree Preservation Act is applicable to Shillong Municipal Area and Cantonment Board, my lord. And for rest of the area, Indian Forest Act is required. And for that, we need to take permission from Ministry of Environment, Forest and Climate Change, my lord. This act is confined to Shillong Municipal Board, Shillong Municipal Area and Cantonment Board, my lord. So for other areas, for national highway expansion and other areas, we have been seeking permission from Ministry of Environment and Forest, my lord, and similar applications are moved. But this act is confined to Shillong Municipal Area only and Cantonment Board, my lord. But inadvertently, it has come that it for the whole of the state, my lord. So it is, the act is only confined to, if you lordship, you kindly see the act of
No, but what
Meghalaya
is applicable to the
Act.
rest of Meghalaya?
Indian Forest, the Forest Conservation Act of 1980, Government of the Central Government Act, my lord. And more precisely, the name of the act is in Hindi, my lord. It is, and we take permission from central government depending upon various
It is Indian Forest Act.
etc. My lord. For example, my lord,
Indian
the
Forest
name of
Act.
the act is Forest Conservation Act. No, my lord, Forest Conservation Act. Forest Conservation Act.
Year?
That is 1980, my lord, and more precisely, my lord, I will place that act also. Name of the act is, my lord, One Sarakshan Evam Samvardhan Adhiniyam 1980.
It's in Hindi.
No, the name is in Hindi.
Hindi, my lord, that's very One Sarakshan Evam Samvardhan Adhiniyam 1980, my lord. And for in English we use it as a Forest Conservation Act, my lord.
Yes. Corruption.
Forest Conservation Act.
Huh?
It will be the Forest Conservation Act, if I'm not mistaken.
Forest Conservation.
Act 1980.
Forest Conservation Act.
Just try to get it.
1980.
And rules? Rules?
Rules are framed under the act only, my lord.
And the application has to be made to?
Central government, depending upon the size of or the forest diversion, because the act itself bars, my lord, if you lordship will have the act, section 2 of the Act of Forest Conservation Act 1980. Section 2, my lord.
You got it?
Forest Conservation Act, my lord.
It's not there.
This is a PIL. Let's put it this way. What is exactly what? It's one thing. We pass this thing. Yes.
You have to copy it.
It's a one-page act.
Show this report.
Show the rules under this.
Section 2, my lord, kindly see section
First
2.
is illegal by
Section 2,
selling by
yeah.
private person. And second,
Because section
Indian
2 of
Forest
the
Act
Act itself clearly
1927.
says- Yes, my lord, and Forest Conservation Act 1980, my lord. This Forest Conservation Act
It's Indian
1980.
Forest Act.
Section 2, your lordship, kindly see section 2.
1927. Forest Act is 1927.
Section 2 of the Forest Conservation Act
with the Forest Conservation Act.
1980.
Okay. It is here, no?
It's one page act, my lord. And section 2, my lord, bars felling of the trees without permission of central government, my lord.
1980.
Section 2, my lord.
Section 2 essentially deals with reserve forest.
And so, my lord, when it comes to notwithstanding anything contained in any other law for time being enforced in a state, no state government or other authority shall make, except with the prior approval of central government, any order directing that any reserve forest within the meaning of reserved forest for time being, or any portion thereof shall cease to be reserved, that any forest land or any portion thereof may be used for any non-forest purposes, my lord. And for the purpose of section, non-forest purpose means the breaking up or clearing any forest land or portion thereof for any purpose there other than reforestation, my lord. So when it comes to felling of trees, my lord, for any developmental project, my lord, from forest area, permission is obtained from central government after following due process, my lord. And for that, afforestation is mandatory, my lord. For example, my lord, there was a, for ropeway, my lord, so for going to Shillong ropeway, my lord, Shillong Peak,
No, that
a
is not the
ropeway
issue
was
here.
envisaged, my lord, and then central government,
That is not the
actually,
issue
your
here.
lordship's order has said that no tree shall be felled. No, the difficulty which we are feeling, my lord, is that because of your lordship's order, that your
This is
lordship has
not for
passed
any
the order
development.
saying that no
Not
tree
for-
shall be.
Not for any development purpose. It is to prevent the trees from falling and causing damage.
Yes, my lord. So to that extent, it is clarified because we have stopped felling of trees in that district because of your lordship's order. If your lordship will see the order of your lordship, where it says that no tree shall be felled, my lord. In this 7th February 2025 order, my lord. So authorities are, even after due permission, even after all permission, my lord, authorities are not permitting the felling of the trees. If your lordship will kindly see 7th February 2025, orders last 4 lines, my lord. If your lordships will peruse the order of your lordship of 7th February and the last paragraph, my lord, in respect of decisions already made allowing felling of trees, but felling of trees not done till today, respondent authorities shall keep the felling of trees in abeyance and review such decision, ensure that they have. So, my lord, if clarification is made that if the permission has been obtained in accordance with law and afforestation has been to be carried out in accordance with the permission under Forest Conservation Act, my lord, because number of projects we are not proceeding, my lord, in due deference to the order of your lordship of 7th February, my lord. And for the private trees, my lord, we will constitute a committee at the level of government of Meghalaya, consisting of secretary and the principal chief conservator officer, my lord, and then they will review each and every after recommendation of DFO, my lord, so that the law is followed to the hilt.
Milids, if I may, in spite of the orders passed by this Honorable Court, Milids, it's a matter of common knowledge that trees are being felled randomly, Milids, all across the state. The forest cover of the state is depleting, Milids, by many a fold every day. It's a common sight, Milids, when we are driving across from this part of the country to some other part, Milids, truckloads of tree trunks, Milids, freshly felled tree trunks are being transported. So these are facts which are staring us at the face of the records. The other aspect is, Milids, your lordships have already seen that it has only become a Milids, formality insofar as Milids, the inspection and the thing has to be carried out by the state authorities. Applications are made and randomly permissions are granted. So that, Milids, in my humble submission, would be require the intervention of this Honorable Court to be stopped.
Yes.
And your lordship kindly see
Because
the
nobody is even exploring the
my friend
possibility
is
of
saying-
lopping the trees, some kind of pruning to be done. What is done is immediately when something is to be made, the first thing is that a tree is to be felled and it is felled. And it is done randomly. So some independent authority, would have to, as is fallen from this Honorable Court, if some independent authority is constituted, my lords, with all stakeholders, that would probably suffice.
Lord, my friend is saying something, Lord, without there being any material. If you Lordship will see one reason, page 73, my Lord, why tree was recommended to be felled in 89 trees, my Lord. Kindly see page 73, my Lord, page 73 of the report, my Lord.
Second paragraph.
Page 73, second paragraph, my Lord. Moreover, I would like to inform you that as per report submitted to your wide office number so-and-so, dated so-and-so, 89 number of trees, standing trees on the ground that they are standing at the proposed site for rectification of black spot location, road section with a high concentration of road traffic accident, often involving fatalities or serious injuries, not on the ground that they are posing trends. So sometimes, my lord, and then you'll also will see at page 76, my lord, the nature of trees, my lord. If you also will see those nature of trees also, my lord. And the species and the girth and the height, my lord, everything is mentioned with, and the GPS location is also mentioned. If
All right.
your lordship will see the girth.
Please take it out. This public interest litigation initially sought orders from this court to stop illegal or irregular felling of trees in and around the lower view colony area, Lightunpra, subsequently, the writ petition, the scope of the writ petition was extended to cover the entire East Khasi Hills district. Paragraph. Now, in view of the developments quoted below, we extend the Cause of action in this writ. To all the districts in the state. Paragraph by our order dated 7th February 2025. We had inter alia directed the state respondents to disclose in a report to disclose in an affidavit all pending applications for felling of trees in the said district in East Khasi Hills district. An affidavit was duly filed. Paragraph on 5th March 2025, it was considered. To invite from the applicants a suitable explanation to their application that a particular tree or a group of trees needed to be felled as it had quotation become dangerous to life and property. Unquote. The state respondents were directed to inspect the trees covered by each and every pending application. Process the applications, take measures to preserve the tree, to preserve trees as far as possible, and only sanction felling which had become so immediately dangerous that if allowed to stand for even some time, it would cause damage to life and property. Full stop. We directed a report to be filed considering the applications for felling of trees and further observed that not a single tree was to be felled till we considered the report. Paragraph. Today, a report dated 9th April 2025 has been placed before us. On perusal of the report, we find that officers of the rank of the range forest officer or beat forest officer have been processing the applications, and that there is a recommendation by them for large-scale felling of trees on the basis of applications made before them on the ground that their position was such that they posed a threat to life and property. Paragraph. Trees are too precious a type of property for this state comma, enhancing its beauty and also contributing to its environment and ecological balance. You make it like this, trees are very precious to the state, contributing to etc. First off, we would only permit their felling if absolutely necessary for the preservation of life and property. Next, we also take judicial notice of the fact that without any application, taking the law into their own hands, many culprits are indiscriminately felling trees then converting the trunks into logs, uploading them in vehicles uploading them in goods transportation vehicles and doing commercial transaction with them on a large scale. Paragraph. In those circumstances, we pass the following directions today. I, unless a particular tree is so imminently dangerous that it cannot be permitted to stand even for some time without causing danger to life and property, the local forest officials may permit felling thereof. Aye. Otherwise, none of the pending applications mentioned in the report dated 9th April 2025 shall be further proceeded with by ordering felling of any tree. Aye. The Chief Secretary of the state will constitute a committee of 3 officials in which the Chief Conservator of Forests should be one, and an expert in botany, whether in government service or private service, should be one, and a senior administrative officer, not below the rank of secretary, the third. Who shall A. Advise the government with regard to steps to be taken to stop indiscriminate felling of trees throughout the state. The government will act in accordance with such advice. Aye. It shall scrutinize the report filed before us, which include the applications to permit felling, along with the report of the local forest officers, make their independent inquiry and issue necessary directions to the forest department to fell the trees or to take any measure for its preservation. Then I4, thereafter the committee will take district by district and deal with the applications for felling of the trees in those districts in like manner, and the local forest officials will act in terms of the order of the committee. Next paragraph without number. We take note of the submission of the learned advocate general. that the Meghalaya Free Preservation Rules Act 1976 and the Meghalaya Free Preservation Rules 1976 apply to the Shillong area only.
Municipality and cantonment areas of Shillong. The Act says
Municipality
that
and
it extends to
cantonment area
municipality.
of Shillong, and that the rest of the state is covered by the Indian Forest Act. And
That act name has been changed of this act, my lord. It's earlier Forest Conservation Act. Now the name has been changed with effect from 1st November 2023, 1st December 23, one Sarakshan Evam Samvardhan Adhiniyam 1980, my lord.
just check it up. Read with the Forest Conservation Act 1981.
When Forest Conservation Act name has been changed, my lord.
Well,
The same act has been name has been.
These are the rules. What my learned friend is referring to, these are the rules of 2023.
No,
These are new rules have been framed under that act.
no. Act has also been, act name has also
Forest
been changed.
Conservation
of the
Act
act.
1980 and the Forest Conservation Rules 2022. Read with any change in nomenclature thereof.
Well,
Wait for me.
The respondent state is to file a report on the basis of the deliberations and decision taken by the above committee before the next returnable date. We make this application returnable on 12 June. That's
Outline.
One submission, last submission, Lord. We have received permission under this Forest Conservation Act 1980, Lord, from central government for various developmental projects, and afforestation activities have been ordered, my lord. So if your lordship may kindly clarify that those permissions have
this
been
has got
obtained.
nothing to do with Mr. Advocate General. This is only to do with
Yes,
Middle
my
College.
lord. Yes, my lord. So, my lord, if one clarification given, because officers are apprehensive, my lord,
So on
and
the-
therefore they are not permitted.
On the submission of the Lord Advocate General, we clarify that this order very necessarily does not cover any case where the central government has accorded permission for forest clearance under the Indian Forest Act 1927 for any development purpose or
on the order.
any direction made by it for deforestation to be followed by afforestation and so on.
I'm forced to intervene because there is an order in this regard, what has fallen now from your lordships. There was an order passed by the 3-judge bench of the Honorable Supreme Court last year with regard to Rule 16 of these rules. So that would also have to be clarified. I don't know whether that would cover this aspect. On the next returnable date, I'll file that judgment and I can assist your lordships as to what is there in that order. Because there were directions to all the states that a committee is to be formed and areas that will be identified. And on the basis of that, the report was to be submitted to the Honorable Supreme Court.
For the purpose of deforestation?
Lordships.
My lord,
The order was passed by the then Honorable Chief Justice, Justice Chandrachud, my lords.
So we have said that
It would not cover, my lords.
it will not cover any sanction made by the central government
My lords.
for
Well, the unfortunate truth is that sometimes sanction is
Central
granted by the
government is-
central government without
government-
considering the local circumstances. That is The
No,
grievance of the
central
professionals.
government. No, my lord, central
We have-
government
we have-
goes
sir,
through each and everything
we have
minutely.
also not been called upon to adjudge upon the validity of any sanction
Melons.
Yes, grateful.
in this way.
Your Lordship has referred to 1927 Act. It is 1980 Act, my Lord. The Forest
That is the-
Conservation Act, 1980.
Yes, this Indian Forest Act is 27.
Indian Forest
But,
Conservation
the
Act
permissions are-
1980, Your Lordship.
Forest Conservation Act permissions are granted under Forest Conservation Act 1980,
All right. Permission
and
under
nomenclature
Forest Conservation Act 1980.
has been changed on 1st December 23 to 1 some.
We have said or any change in nomenclature. If you can find out, Mr. Ram,
yes,
give it. Obliged.
yes, my lord, I'll give. Okay.
Last but not least.
There's the Passover item.
ये होने का बात होगा.
Number 4.
Yes.
Please, Your Lordship. Issue involved in this case is, my lord, the letter of acceptance has been issued to the appellant by the FCI for transportation of goods. With certain conditions, they should sign the tender documents, hard copies, and he should deposit the security deposit in the form of bank guarantee. Failing which,
This is an appeal which is ready for hearing.
it's an appeal, pardon? My lord?
Ready for hearing.
Yes, but it's come in the hearing column only. Lordship has fixed this today for hearing, my lord. Item number 4. And Lordship also directed me, my lord, to prepare a paper book. I also made the paper book.
All right.
It's there.
1 minute. Yes, pass over. You just wait.
My lord.
Yes, call the next item.
Number 5.
Someone's ready.
Lordship, we are ready for the hearing. It's a writ appeal.
All right. Pass over. Next.
Number 6.
Need, please, Lordship.
Yes.
Lordship, there was some personal difficulty of the counsel on last date of hearing, Lord.
Yes. The hearing was concluded here. No.
Part hearing was concluded, my lord. Almost I concluded my argument, my lord. My learned friend
Practically,
was
Lord,
to,
there was a direction to file an affidavit by the state. The state has filed the affidavit, and thereafter I filed a reply. Filed a reply. That is the stage. But the further consideration on the basis of the affidavits have not taken place.
All right. Pass over at the first one.
Your lordship may adjourn it after a week or 10 days, my lord. This will require some hearing, my lord. Both affidavits have to be shown to your lordship.
No, it is all
Your
right.
lordship may have it.
So instead of adjourning it, we will go matter by matter. If you are, if it is time of call, you have difficulty, we will adjourn it then.
Yes.
Yes. Call the next matter.
Number 8.
Please, my lords.
Yes.
My lords, this is a matter, I will not take more than 2 minutes.
Yes.
This is a matter that has been heard by both parties.
Yes, it was not
heard by
CMU.
your
Then it
lord.
was.
Yes, my lords. It's just that post the conclusion of the hearing, the Supreme Court pronounced a recent judgment in JSW Steel. My colleague has just handed it over. I will not take more than 2 minutes to explain the relevance of this judgment for this honorable court to consider.
Yes.
My lords, we have already handed over a copy to the learned Advocate General.
Yes.
My lords will recollect one of the submissions of the appellant in this matter was the implications of the Supreme Court judgment in Rainbow Papers.
Yes.
This, my lords, is the first judgment of the Supreme Court that directly deals with Ghanshyam Mishra on extinguishment of a claim and Rainbow Papers.
Yes.
If my lords would please have first paragraph 3. My lords, it is a contempt judgment. I don't want to get into the facts. In fact, my lord, I understand the facts are identical. I only wish to point out, like in this case, in our case, even in this case, a public notice was issued and no reply or claim was filed. Would my lords please have paragraph 12 at page 10?
Yes.
My lords, this is the argument of the state in that case. Ms. Pragati Mitra further submitted that the judgment of this court in Ghanshyam Mishra was not applicable in the present case, inasmuch as neither the state of Chhattisgarh nor any authorities were made parties in the insolvency proceedings before the NCLT. She further submits that the judgment of this court would not bind the respondent as such in case of contempt was not made out. Would my lords please have the next page?
Yes.
To buttress her submissions, Ms. Nikra relied on the judgment of this honorable court in State Tax Officer versus Rainbow Papers. This was the submission identical to the present case. Now, my lords, in paragraph 14, the Honorable Supreme Court held the legal position is no longer res integra. This court in Ghanshyam Mishra has considered a batch of petitions. Then, my lord, the court sets out, but the summary, my lord, of what it wishes to say is in paragraph 22. May I be permitted to read, my lord?
Yes.
It can thus be seen that in view of the clear pronouncement of law by this court, all the dues of any stakeholders, including statutory dues owed to the central government and any state government or local authority, which were not part of the resolution plan, stood extinguished from the date the resolution plan got approved.
Yes.
Then, my lord, is the argument of the state in that case, which is at para 28. Only two more paragraphs I wish to read. I'm very grateful for this honorable court to indulge us. At page 20, my lord, paragraph 28.
Yes.
Coming to the next submission of the learned counsel for the respondents, insofar as reliance placed by her on the judgment of this court in Rainbow Papers is concerned, this court, in the said case, this court was considering the question as to whether the provisions of the code, and in particular section 53, would override section 48 of the Gujarat Value Added Tax. We find that on the facts, the said judgment is not applicable. Next paragraph, my lord. In the said case, in response to the advertisement issued by the RP, the state tax officer raised its claim. My lord, may please note, this is the same point we were making. In Rainbow Paper, the claim was in fact filed, but not considered. In our case, like in the case in JSW, no claim was filed. The claim of the state tax officer was rejected by the committee. The learned NCLT also rejected the claim of the state tax officer, and an appeal came to be dismissed by the NCLAT. Aggrieved thereby, the state tax officer approached the court. Would my lords now please have para 31 and 33? These are the last two paragraphs I wish to refer. In that view of the matter, we are of the considered opinion that the facts of the Rainbow Papers case are totally distinguishable from the present case. In Rainbow Papers, the state tax officer had raised the claim before the COC, which was not taken into consideration by the COC. As such, the court came to a finding that the satisfaction arrived at by the adjudicating authority was vitiated. Undoubtedly, in the present case, in spite of public notice, neither the state of Chhattisgarh nor its authorities raised any claim before the COC. My lords, this is identical in the present case before you. In that view of the matter, we are of the considered view that the case of the petitioner is specifically covered by the judgment of this court in Ghanshyam Mishra, which judgment was brought to the notice of the authorities. The respondent authorities could not have proceeded with the recovery proceeding. My lord, this fact is also identical. I'm very grateful, my lords, for the time.
My lord, only two submissions. Your lordship, kindly see paragraph 3.2 of the judgment. In fact, paragraph 3.1 at page 2, my lord.
Yes.
And this lordship contempt proceeding was initiated against Monet Ispat Energy Limited. In paragraph 3.1, it is noted. Insolvency proceedings were initiated against Monet against an erstwhile company, Monet Ispat Energy Limited, as per Insolvency and Bankruptcy Code 2016. And then your lordship kindly see paragraph 3.2.
Yes.
Thereafter, various demand notices were raised upon petitioner company by Odisha Mining Corporation for recovery of sale tax against iron ore, aggrieved by demand notice, claiming that dues were extinguished as per code because they were raised for a period before the management of erstwhile company was taken over by the petitioner company. 3.3. Various similar matters were tagged together by this court, including aforesaid
No, what
petitions,
are
while
you
common
trying to
judge-
submit, Mr. Advocate General?
I'm submitting, my lord, that in Ghanshyam Misra, this matter was tagged. And in Ghanshyam Misra, the judgment was covering Monet Ispat also. So therefore, the court has held that rainbow papers is distinguishable on facts. If the lordship has seen the paragraph read by my learned colleague, saying that on facts, rainbow papers are because this very case, my lord, was tagged with Ghanshyam Misra, and whatever was held in Ghanshyam Misra is applicable to this case. Therefore, this case is not an authority on the point that the claim which have not been included in the resolution process will get extinguished, my lord. This judgment is not the authority on that proposition, my lord. And my friend is saying that this judgment has distinguished rainbow paper. This judgment says, my lord, in that on facts it is distinguishable, my lord. And your lordship would recall, here the claim was raised by me against Summit Digital Infrastructure. They are not the entities which went to IRP. They were not the entities which they seeking.
You have not raised a claim upon them. They have applied for electricity.
Yes.
You have said you will not give them because the dues of your holding company is pending. Or your group
Now the
company.
question the question is, my lord, that holding company, they are not the holding company. They are all independent legal
But
entities.
on that ground,
Holding companies.
On that, you have not made an independent claim anywhere up to now. You are blocking their claim on the ground that I have my dues. And they are seeking a declaration of
dues
dues.
My lord, I have my dues from against Summit.
Yes, respondent number 1.
Yes, my lord. My lords are absolutely correct. That is what is happening.
Summit Digital Infrastructure came to me for electricity connection. I said that these towers are having due and you are seeking connection. Therefore, you have to make the payment. Now, Summit Digital Infrastructure is not seeking the protection under the resolution plan. This is being sought by a company which says that, and it's pleading, I have shown, my lord, and I will file written submission. In pleading, they are saying that all are independent companies, my lord. That is one aspect of the matter, my lord. Second, what we have said, that statutory obligations under the, assuming that statutory dues are covered under the plan, my lord, the final approval of NCLT clearly says that all statutory obligations are not covered. That point also I have made, my lord. So first point I have made, my lord, that Summit Digital Infrastructure is an independent entity. I am seeking claim from Summit. Summit is not coming before you, your lordship, and therefore the successful resolution applicant can't come before your lordship and seek protection under the IBC Act. That is one, my lord. Second point which I am making is, my lord, that even assuming that this resolution plan covers the respond number 3 and 4, Summit and Geo Infocom, they are not aggrieved, my lord. They are not aggrieved. The successful resolution applicant is saying that no, you cannot claim it from the third party. And they are not the holding company, my lord. There is no pleading anywhere that they are holding company.
Very well. If respondent number 3 and 4 and 1, according to your independent companies, then you cannot pay.
Yes,
then you cannot deny electricity to 3 and 4 on the ground that respondent number 1's dues are pending. Because you are holding,
therefore,
because you are holding them to be group companies, on the same thing that Australia, one of our houses is dues are pending, so the present applicant for electricity will not get unless that due is cleared. On that principle, you are
Slightly different point I am trying to make, Milord. What
So
the
once
point I
you
am trying to
say, if
make
you
is
say
that
that they are independent companies, then there is no reason why you can deny them electricity, because they have no connection with
So-
R1 according to you. Once you say they have
the
connection with
point,
R1,
yeah.
because of
Yes,
their
Milord.
pending dues, you are denying them. That is the
See,
thing.
Milord, if I take the analogy further, Milord, the new owner of the company, new owner of the house is not protesting against denial of electricity connection, Milord. Then whether the earlier owner can come before your lordship and say that no, the new owner should be provided with the electricity connection, that's the locus of the new owner, the old owner, Milord. Locus of the old owner before your lordship. That is my point. Third point which I am making, Milord, assuming that they are group companies, they are thing, is even under the resolution plan, Milord, your lordship has seen that under the resolution plan that statutory obligations have not been waived. And my friend is trying to make a finer distinction in written submission by saying that statutory dues are different from statutory obligations. And fourth point which I have made, Milord, is that all these issues, if my friend has some confusion, all these issues could have been taken up by him in the NCLT, because NCLT has the authority under the Act to clarify this aspect of the matter, Milord.
NCLT
My
up to
friend
the
has-
time, NCLT up to the time it is pending before it. So once
No,
it
my
is,
lord, even after that.
you see
Even
the
after
section
that,
61.
61.
61.
61. Kindly see
So
section
once
61.
it is
Yes, my lord. Kindly see section.
final,
No, lordship, kindly see section 60. No, kindly see section 60 for a moment, my lord. Section 60, subsection 5C, my lord. Section 60 of the Act, my lord.
so
Section
as
60.
long as it is pending, it can consider
No, my
any.
lord, that section says. No, even after, my lord, even after the matter is over, the matter can be considered. In fact, my lord, I have a recent judgment of last month, my lord, of Reliance Infotel only.
Before NCLT, if you are agreed by any
No,
resolution
it will go.
process. But you have
So
also,
then, my lord, if you
then there is also a special period of limitation there. There is no application pending before that. Had one scrap of paper been pending before NCLT, we would have said that yes, it is for the time being extinguished, but it may be rekindled if you succeed before NCLT. But there is nothing before NCLT.
if I read, my lord, see, my lord, any question of priorities or any question of law of act arising out of or in relation to insolvency, resolution, or liquidation proceedings of the corporate debtor or corporate under this act. So any proceeding, my lord, the words are quite wide. Even post facto clarification, they can go back to the NCLT, my lord, and in written
No,
submission,
but
my lord,
read the
this-
first line. Please read the first line.
Milord, I read this, Milord, notwithstanding any
No, first opening words of the section.
entertain or dispose of any question of priorities or any question of law or facts arising out of or in relation to insolvency resolution or liquidation proceeding of the corporate debtor or corporate person under the code. So 63, 60, subsection 5C, Milord, leaves the scope for NCLT to entertain even after resolution plan has been approved, my lord. And I have the judgment of recent Supreme Court judgment
No,
with
no,
respect
please
of
read
this company only, my lord.
section 60, subsection 2. We must go
Yes, my
through it
lord. Without,
logically.
Yes.
Where the
you will see
corporate
that also
insolvency,
without prejudice.
this is the problem with virtual hearing. Buffering,
But I'm sorry, I'm sorry.
where a corporate insolvency resolution process or liquidation proceeding of a corporate debtor is pending before a national, so it doesn't give a full rope. And when it is pending, you have to come with an application. If you have not gone,
And if you also will,
that is why no
In
time
fact,
limit is given. In 3, 4, 5, no time limit is given. Because as long as it is pending, you can make an application. If you don't, then you may have a remedy by appeal before the appellate tribunal.
In fact, my lord, may I please add? May I please add one point, my lord? My lords are absolutely right. The Supreme Court in Tata Power, which is a judgment we cited before you, has said that if the state has any grievance, the state can go to the NCLT. The company is not required to go to the NCLT under 60 subsection 5. And the Honorable Calcutta High Court, the Allahabad High Court, and numerous decisions have held that writ petitions are
But with
maintainable for
respect to the Supreme Court, a debt can never be extinguished at any point of time. Any debt has in its nature can be rekindled in an appropriate forum. And number
I'm very
two,
grateful. That is correct.
very jurisdiction, NCLT will declare it is extinguished. That is the second point. In another jurisdiction, a court will not say this is extinguished. If it is a suit, in an appeal,
Yes.
the court will say that so-and-so debt is decreed or declared in this way. But if a suit is pending, a writ court will not say it is decreed or declared, etc. This, with due respect, is a little anomaly in the Supreme Court judgments.
I'm very grateful, my lord.
The NCLT declares that it is extinguished and extinguished for good, it is extinguished for good in an appropriate jurisdiction. That is the forum for it. But not in an
Very
ancillary jurisdiction. Because in the natural jurisdiction, there is always a chance for the debt to be rekindled.
I'm very grateful for my lord's observation.
Suppose the list of debtors have not been as provided in Rainbow.
I'm very
These
grateful.
are the other observations in this court with regard to the Supreme Court judgments also. And
I'm
we were
very
doing this
grateful for my
without
lord's
them.
observation.
Alright.
I'm very
We are
grateful.
very
Yes, my lord. May I just add one point?
No,
The-
nothing.
I'm very grateful.
We'll
We
file
are
written
very
submission, my lord.
grateful.
I'll
Yes.
file my written submission, my lord.
Yes. We have heard both learned counsel. On their citing, on learned counsel for the respondent citing JSW Steel Limited versus Pratishta Thakur, Haritwal and others. Decided by the Supreme Court on 7th March 2025. We shall consider the said decision. Hearing concluded, CAV. Hello.
Thank you very much for your time, ma'am.
Yes, thank you. Mr. Shah, just 5 minutes. Yes, who's in item number 9?
Lord, this matter came up yesterday and it was heard at length also.
Yes.
My Lord, I have got a judgment, but I'll require some more time, my Lord. If your Lordships can kindly have this matter on the 23rd or 24th minute.
Lordship, yes.
By consent of learned counsel for the parties, this writ petition is adjourned till 24th April.
Indeed. Highly alive, my Lord.
Second call, number 1.
Yes.
Please, your lordships, my lord.
Yes.
This is an appeal against an order dated 21st March 2025, which has dismissed my Section 9 application. And my lord, very interestingly, when the Section 9 application was moved, my lord, there was an order of injunction passed in my favor, restraining the authorities from interfering by possession of the land in question where I had set up a state-of-the-art diagnostic center. My lord, thereafter, my lord, there was a lag in the order, and my lord, there was an assurance given by the authorities that they will not, my lord, take any coercive step. Notwithstanding such fact, my lord, they were forcibly repossessed, my lord, the premises in question. My lord, in such circumstances, a repossession application was made in the Section 9 proceeding, and my lord, on 19th of March 2025, repossession was directed. Thereafter, the matter came up for final hearing. In the final hearing, very strangely, application was dismissed on the ground that the entity with which the memorandum of understanding had been entered into was not the entity with which the transactions had taken place because of a small typographical error in the order. This also is clearly covered by the Cox and King's judgment of the Supreme Court now, which talks about which of the non-parties also can be bound by arbitration agreement. Well, this of course was not considered. Well, all that I'm praying is that well, they have taken over possession. My equipment, my goods, well, they're all inside. My cases for specific performance. The agreement by its very nature says it is non-determinable for the period stipulated in the agreement. So, well, let status quo be maintained. Well, I will be appearing before Your Lordships physically on the 22nd, 23rd, 24th in the other matter that Your Lordships have fixed. I can come and argue it. It's a very short matter. Well, Your Lordship will not take much time. But till then, if they
Where is
remove
the
my goods and
improved-
throw it away, if
Where
they,
is the improved order, Mr. Shah?
yes, well, that impugned order Your Lordship will find is at page 68. Or I'm sorry, it's the operative portion is at 68. It starts at page
34, my lord.
34. Well, Your Lordship need not, my lord, to go the entire distance. Starts at 34. The relevant portion is at 68.
Is on the maintainability point dismissed?
Yes. And well, Lordship will kindly see, initially when Section 9 moved, satisfied by a very lengthy judgment, injunction passed. Then, my lord, when I am dispossessed forcibly, my lord, very well considered judgment, my lord, I am directed to be put back into possession. Now, my lord, the Section 9 is dismissed on maintainability. And, my lord, on the ground, if your lordship kindly have a look at the MOU, my lord, that your lordship will find at page 98.
No, what was the relief you sought in this application?
Well, the relief I sought
Stay on the termination of
your
the-
lordship will kindly see. Well, as for the time being, I'm saying, well, termination, stay on the order of termination of my Section 9 application. And, well, status quo, because, well, they should not interfere with the goods, my articles, but that in the premises now. I have won all through. I've been protected all through. But then suddenly, well, the court finds that the description of the party in the MOU and the description of the party with which the state has transacted all through is different. So, therefore, this party is not covered by the arbitration clause in the agreement. Well, at that situation, it's a mistake, nothing more than a mistake. The parties have accepted performance by another party, which is in fact the same party or the assignee of the same party. But most importantly, this point is now covered by the Supreme Court judgment in Cox and Kings, where even non-parties to arbitration agreements are covered. When the nexus is very intrinsic. That is the only point, nothing else. On merits of both is found in my favor throughout. If my learned friends, my learned friend will have a chance to argue it. My lord, we will address your lordships. I am only saying for the time being, my lord, there should be status quo, my lord, maintained so that, my lord, I am not put to further prejudice. That is all.
My lordship, the issue, my lord, issue in this case is, my lord, that the applicant has entered into the MOU with the state government, my lord. And termination of the MOU by the state government was not against the applicant. Applicant is not the signatory of the agreement with the state government, my lord. That is one. Second, my lord,
that is exactly the point on which I wish to address your lordship. My lord, this cannot be the issue.
Let me
Yes.
finish.
My lord, we
One
will
minute,
have to
Mr.
argue
Rahab.
this.
We
We'll
have
have to
both
argue
understood.
this.
Yes.
Second point, my lord. Second point which you have, if your lordship will see, that there is no agreement with the applicant. There is no agreement. The state has not entered into the agreement. It is an independent juristic entity, Lord. But at this point of time, Lord, because the parties, we have no hesitation in resolving the dispute amicably outside the court, Lord. What I was saying, my lord, that if the matter is adjourned for a week or 10 days, and then in the meantime, the parties can sit and discuss because, my lord, this premise is being used for the medical college, upcoming medical college. Lord.
Where is the Section
And
9 application?
Section 9 application will, Your Lordship will
My
find.
lord, that is at page 30, my lord.
Look. Well, Page
But I think, my lord,
246, my lord.
246.
246, my lord.
Annexure 30, page 246. And the prayers are at, my lord, 265.
State is not involved, Mr. Advocate General. You are appealing for a private party.
Well, state is involved.
State, my lord. And there is a clear bar under the specific relief act, my lord. Statute bar no injunction in respect of infrastructure project, my lord. And it is a medical college project, my lord.
Well, lord, it is not an injunction against the infrastructure project. It is an injunction, my lord, against, my lord, termination for contract wrongfully. It's wrongful termination of the contract that we
And
received.
if it termine,
We are
all
seeking
contracts are
specific
terminated, my
performance.
lord. My friend has asked for the compensation, my lord. That can be negotiated and discussed. If you also will kindly see page 165 of the paper book, my lord. And total claim in that paper, in page 165 is 5 crore rupees, my lord. If my friend is willing and ready to negotiate and discuss, we can resolve this matter out of the court and we can resolve this issue by some damage also, my lord, compensation also. His total claim is 5 crore rupees. And any status quo, my lord, will jeopardize the medical college, my lord. Medical college application has already been, and the entire premises will be used for the medical college, my lord, and classrooms, my lord. My friend has got monetary claim, and monetary claim
No, my lord.
will be compensated, my lord. There is absolutely no issue on that, my lord.
Well, lord,
If
that
my
is not
friend
the case.
succeed, he
My
will
lord, with
get the
the
monetary
deepest
claim, my
respect,
lord.
the same argument was advanced, did not succeed before, my lord, the court below. My lord, the section 9 application succeeded, my lord, at the Addington stage. Dispossession was wrongfully done.
And if you also will see name of the party, kindly see the name of the party. Name of the party is Suraksha Salvia LLP. And who are the signatories, my lord? Suraksha Salvia LLP is not the signatory. It was not even
Then
born
why
on the
did they
date of the
terminate
MOU.
Then why did they terminate
Kindly
the
see
agreement
page
with Suraksha
98,
Silvia?
page 98, my lord, of the MOU, my lord,
Well, if I am not a party to the
which is
MOU,
with
then
the
why did they
government.
terminate me?
Page 98 is the MOU, my lord.
Well, kindly see, my lord, they have issued a letter
You
of termination.
terminated the contract on the sole ground that according to you, they were not the entity with whom you contracted. That's all.
Yes, my lord. And section 9 will be by, section 9 application will be by entity who has signed the contract with me, my lord. Because section 21 of the Arbitration Act clearly says so.
So, till we decide the prima facie case at least, let the
Kindly see, my lord,
equipments and other gadgets remain.
Network issue is there, my lord. I'm really sorry. Here.
Kindly fix a short date. Your lordship is, my lord, already, my lord, has directed me to appear before lordship on the 22nd. Kindly hear out the matter. It's a very short matter. But till then, let them not disturb, my lord, disturb my possession of.
Lord, because the status quo will jeopardize my medical college. Lord, they will get the compensation. They will get the money. There is no issue on that. If they succeed, they will get the money, my lord. And the premises is in my possession.
No, my lord, if the entire arbitration, my lord, that is wrongfully taken. That was in violation of an order, and that's why repossession was directed. If status quo is not granted, my lord, the entire arbitration will become infructuous at this point.
Let it remain for some time. Yes, please
Lord,
tell
the
them.
only issue is, Lord, that medical colleges inspection is going to commence any day, and the entire building is in my possession.
Well, how?
My
how
friend
can
will
they
be
have taken possession?
When did you enter into contract with them?
I entered in the contract with them. I did not enter a
2019.
contract with him. My lord, the applicant, I did not. In
No, no,
2019, my lord.
how long they are operating there?
Your lordship, they have been
2019.
operating 2019, my lord, and we have offered them alternate premises also, my lord, because there is no provision for us to give them the place, my lord. Your lordship will see the contract, my lord. Kindly see the contract. What is the contract says, my lord?
Well, let
Because they have
kindly see the
occupied
period
it
of the contract.
illegally. Your lordship
Well,
will
kindly
see
see the
kindly.
period of the contract at page 102. It is valid for a period of 10
So, my
years.
lord, this is a infrastructure project, my lord, and kindly see page 100, page 100, my lord.
Well,
Page
please see
100 of
clause
MOU, my lord.
14.3 at page 105.
And they are not
Kindly
even
want to see it.
signatory to the contract, my lord. This contract is dated June, 21st June, my lord, 2019. And this
Well,
entity, my lord, which has filed the case came
well,
into existence
kindly,
only on 21st August 2019.
well, I shall show your lordship all the minutes, all the letters, all the
100,
documents, all
page
the
100, your
also
lordship will see
telling
page
them
100 and
transacted
first
with me.
responsibilities of private partner. What is their responsibility, my lord?
Well, let kindly
To
see
set up a
clause
center at the
14.3.
requisite site.
Let
My
my
lord,
learned
site,
friend
they have
show to
not
your
set up any
lordship, well,
center
the
so far.
number of transactions they've done to me.
And then your lordship kindly see this termination letter, my
Over
lord. There
the
is
years,
nothing.
then why did they transact with me?
237, my lord, 237. Termination letter, my lord.
Well, please see, well, clause 14.3 first.
237,
Well,
my
that
lord.
your lordship will find page 105.
My lord, they are not even party,
Well, kindly see
they
clause
have not
14.3
acted on
at
the
page
contract, and
105.
termination letter, my lord, is detailed one which gives clear and cogent reasons, my lord. Kindly see page 237. There is nothing wrong in page
Well,
237.
the court
Or
has
order of
held that the
termination 30
termination
January
was wrongful.
2025, my lord.
The court held that the termination is wrongful. The court held that the repossession is wrongful. The court
Paragraph
directed
2
my
of page
that they need to
237,
be
my lord.
put back into possession. Well, kindly have a look at 44, the agreement first. That's at clause
237, my lord.
14.3 at page 105. Specifically says that the MOU shall be specifically enforceable at the instance of any party. The parties agree that a non-defaulting party will suffer immediate, material, immeasurable, continuing, and irreparable damage and harm in the event of any breach of this MOU, and the remedies that applicable law in respect to such breach will be inadequate. And well, the period is very clearly mentioned. The period is 10 years. So at least till 2029, well, I have to be in possession.
Paragraph 4 at 237, my lord. Kindly see paragraph 4 at 237. Suraksha Selvia Global LLP is the entity, my lord.
Well, kindly see the
And
section
they
9
were
order.
required to set up diagnostic center.
Where is the improved order,
Well, then
please?
why did they do business with me?
Page 237, my lord. 237.
Well, they impugn.
No, improved order.
Paragraph 4, 237, 30th January 2025, my
Well,
lord.
impugned order is well,
Paragraph 4 at
Impugn
237.
order, my lord, is at
No, no.
34.
No. 21st March. Well, that's a relevant portion is at 68. It starts at page 34.
All right, please take it out. This is an appeal from a judgment and order dated 21st March 2025, dismissing an application by the appellant under Section 9 of the Arbitration and Conciliation Act 1996. We find that in this application very vexed questions arising out of a memorandum of understanding between the government and Suraksha Salvia Global LLP dated 21/6/2019.
No. Well, not global. Well, global is the mistake. Suraksha Salvi LLP, well, is what we are. The petition is Suraksha Salvi LLP.
No, The 237 says Suraksha Salvia Global LLP.
Does the
Your
party
Lordship will
concerned?
see at page 198. Agreement is 98, my lord.
May I
Suraksha
just-
Salvia Global LLP.
My lord, may I just
And Suraksha
Well, may I
Specialty
just
LLP.
clarify this position? Well, may I just clarify this position? The agreement was entered into with Global. My lord, thereafter, my lord, the business was carried on for the last 5 years with Suraksha Salvi LLP. Then they, my lord, they suddenly decide to terminate Global. Now, my lord, today, Suraksha Salvi LLP approaches court. The court finds, my lord, in its favor, passes an ad interim order. Court, my lord, then, my lord, when
Yes,
it's
yes, we have
forcibly
heard
disposal,
that.
directed repossession of. Yes.
Yes, memorandum of understanding is Suraksha Salvia Global Limited. Page 98.
That's right.
Suraksha Salvia Global LLP and Your Lordship at page 99, the second company is Suraksha Specialty LLP. These are the two companies, my lord, with which government entered into the MOU. Suraksha Specialty LLP and Suraksha Salvia Global LLP.
I'm looking at page 98.
Yes, my lord.
Well, if your
That is
lordship sees the
Suraksha
minute,
Salvia Global LLP. And if your lordship will notice at the bottom, Salvia Global LLP signature is there, my lord. And Secretary Government of
No, no,
Meghalaya
who-
signature is there.
And the petitioner is
well, please see, my lord, just
Suraksha
one document.
Salvia LLP.
This is a new company, my lord. This is a new
That's
LLP.
right.
This is a new LLP.
No, my lord. This is the, my lord, company with which they have been transacting throughout under
All
this
right, all
MOU.
right.
And my lord, kindly see the minutes of the meeting.
And
They've
Mr.
been
Shah, I have
transacting
heard
with
you.
Suraksha Salvi
Please,
LLP, not
please,
Global.
please.
Yes, ma'am. I'm sorry.
And
I'm sorry, my lord. I'm sorry.
Suraksha Salvia Global LLP and Government of Meghalaya. The contention is that the agreement is also valid and binding between Suraksha Salvia LLP and the government. The initial point taken in the Section 9 application by the respondent was that the applicant before the court was not a party to the arbitration agreement, and that on this technical ground, the application was dismissed. The merits were not even addressed. Paragraph, therefore, in this appeal, we have to first go into the maintainability point and thereafter enter into the merits if necessary. As the parties are represented before us, now we formally admit the appeal. Next, as the parties are represented before us, we dispense with all formalities and expedite hearing of the appeal. Advocate on record for the appellant shall file an informal paper book by report. by 24th April and served. A copy on the respondent's advocate of record at least 7 days before the date of hearing of the appeal. List this appeal for hearing on 14th May.
Grateful, very grateful.
Considering the fact that the merits of the matter have not been addressed and that all the equipments and gadgets of the appellant are stored
Have been preserved and will not be
in the place of business of the appellant. Which is the subject matter of this litigation. Let status quo regarding this possession be maintained until this court is in a position to hear of the appeal. Liberty is granted to either party for mentioning this appeal for expeditious hearing thereof. That's all. Maintain the status quo regarding these equipments.
Your Lordship, only one request, my Lord. We have maintained and preserved their equipment, etc. We are ready to hand over the entire equipment also to them, my Lord. There is whatever equipment, and it is from my money only. So we will
No, my
maintain,
lord.
my Lord. Only thing is that, my Lord,
This order
Let
will
us
not.
come back and argue it.
This order will not prevent the parties to enter into an amicable arrangement for relocation of the equipments to an alternative place.
Very great.
Number 4.
Four, five, Amen.
Yes, my lord. I'm appearing for the appellant.
They will appear in tomorrow's list.
My lord, if I submit, my lord, we will file my written argument, my lord, and if this matter be taken up in the month of May, my lord, if it is not inconvenient to your lordship, my lord.
Item number 4.
Item number 4, my lord. Since we both parties come from Guwahati, my lord.
No, you stay one day, we will take up this matter tomorrow. Huh?
Youth court. Calendar court de.
Then please agree to a date in as early as possible.
কেটে করব reopening date May 28.
28 is not it. What about it? 28.
Or if you can do it on Friday, do it on Friday.
My lord is so busy, he's going out to upstate because we are having vacation, my lord. On 28, my lord. 28. April. No, 28, my lord. Wait, everything is ready here in this case, my lord.
You are not here this Friday.
My lord?
You cannot.
No, my lord. We have other matters also, fixed matter in Guwahati High Court, my lord, tomorrow. So 28 is fine, my lord.
Who's for the appellant?
And for the appellant.
All right, by consent of learned counsel for the parties, list this appeal on
28.
28.
April.
Number 5.
Obliged, my lord. Hope my luck will click on that day, my lord.
Yes.
Hope my luck will click on that day.
Obliged, my lord.
Ruling item number 5.
I pay for the appellant. I pay for the appellant, Lordship.
Yes.
Lordship is the judgment, appeal against the judgment of the learned single judge, while the appellant serving in the police department was dismissed from service on account of 96 days of unauthorized absence, which was caused due to medical exigency, Lordship.
You do this matter on Friday? Who's for the respondent?
I'm for the state respondents.
Friday. This appeal is fixed for further hearing on 11th.
Obliged.
Number 6 and 7.
Lordship, we have it in the week commencing 21st, my lord. This matter for
21st.
yes, my lord, be commencing 21st or thereafter, my lord, whatever is convenient to my friend.
28th.
My lord, 20, can it be on 6th of May, my lord?
Yes, Mr. Advocate General.
No, Lordship, I'm the one
Yes, my
who
lord,
is.
6 May. 6 May.
Earliest, please give a date.
Or 24th of April, if your lordship.
24th of April, all right. By consent,
Yes,
24th of April.
24 May.
21st, no? 24th.
Yes.
I'm not able to go to Delhi to meet my son, because of.
Okay.